Very good evening to all of you. So we will continue with the discussion on current affairs, and as you all are aware, very good evening to all of you. So we will continue with the discussion on current affairs, and as you all are aware that today we are scheduled for taking up the current and contemporary developments related with polity and constitution, on which you may expect questions in the prelims 2020. So the first topic which we are taking up for the discussion relates with disqualification powers of speaker pertaining to related with anti-defection law. So year long 2019 we saw the 10th schedule of Indian Constitution in news related with the developments in the state of Manipur, thereafter in the state of Karnataka, thereafter in the state of Madhya Pradesh. Then in January 2020, a historic judgment of Honorable Supreme Court came related with the power of the speaker to disqualify members as far as 10th schedule is concerned. And even after this historic judgment, again the matter has reached to Supreme Court, and this time it has reached to the developments which we saw in the state of Rajasthan. So for prelims, this is a very important topic from polity which we are going to take up for discussion. So the topic is disqualification powers of speaker, disqualification powers of speaker, and right, we will be primarily talking about the historic judgment pronounced by Honorable Supreme Court of India in a plea which was filed by Kesham Meghchandra Singh, who was a legislator in Manipur Legislative Assembly, right, against Manipur Legislative Assembly Speaker. So he filed a plea, and while entertaining the plea, the Supreme Court has come up with a historic judgment in which Supreme Court has said something you need to know: Legislative Assembly Speaker. Okay, so disqualification powers of speaker, and this is related with 10th schedule of Indian Constitution. I would just like you all first to understand the 10th schedule. Okay, so what I would like you all to remember, that this 10th schedule, this is anti-defection law. This is anti-defection law, and this was included in Indian Constitution first time as per 52nd Constitutional Amendment Act of 1985, and again it was amended as per 91st Constitutional Amendment Act of 2003. So some amendments were done, and this 10th schedule, which is anti-defection law, is basically a constitutional provision to fight the political evil of defection. Because one thing what is weakening our democracy and what is taking our democracy away from the path of ideology is the opportunity-centric political defections, and that is a cause of grave concern, right? So to combat that political evil of political defection, in 1985, for the first time, Indian Parliament amended the Constitution, included 10th schedule and included anti-defection law, but then also we found that this evil continued in some other form. So to make it effective, again some amendments were done through 91st Constitutional Amendment Act of 2003, right, 91st Amendment Act of 2003. And what I would just like you all to remember, within this anti-defection law, the power to disqualify is with the Speaker of the House, that is the presiding officer of the House. And who will be disqualified under anti-defection law? I don't think that in current affairs I need to tell you, but very quickly, just for your understanding and a quick revision, I would like to say that number one, anybody who voluntarily gives up the membership of political party after getting elected on the symbol of the political party under anti-defection law, their membership of the house he can be disqualified from the membership of the house by the speaker. So anyone who is winning, right, on a party symbol and thereafter voluntarily is giving up the membership of political party, this is the first provision which is there under this. And second provision, which is again very, very important, that if the member of the house is voting against the directive of the party or is abstaining from the voting, even when he was asked by the party to be present in the house and to vote, right, and to take part in the vote, and then in such case, if the party is, condoning the action of that member within 15 days, then this can also be the ground. So anybody who is violating the whip when the house is in session, that can be the ground. And what are the exemptions which are there? Okay, what are the exemptions which are there? Exemption is that if 2/3 of the members are in favor of merger of the party with other party, then it will not attract disqualification under anti-defection law. And second important thing is that if the presiding officer of the house, somebody who got elected as the presiding officer of the house, if he is resigning voluntarily from the party to maintain the sanctity of impartial functioning, and thereafter is joining the party back after the dissolution of the house, then this will also not attract disqualification under anti-defection law. But what we have seen, that if speakers have started interpreting the power of disqualification in accordance with what they are asked by the senior political leaders of the party which they belong, and that has given birth to serious nature, constitutional and political crisis in many states, as well as in the center on different occasions, and this is the cause of concern, right? This is the cause of concern. I would just like you all to remember that recently the Supreme Court has come up with a historic judgment, right, in which Supreme Court has said something, and we will have to see whether what was said by Supreme Court is going to be, right, implemented or not. Time will only tell. But I would like you all on this, a full-fledged question was even asked in the main exam. You all should remember the very famous case Quixote Colahan versus Zetchi, right? This case, this is of 1993, right? This is of 1993, and in this case, the Honorable Single Judge Bench of Honorable Supreme Court related with anti-defection law, right? Supreme Court declared that in this case, Supreme Court declared that decision of speaker in matters related to disqualification under 10th schedule is not final, and can be questioned in any court, and any court meaning High Court, and thereafter the Supreme Court. Okay. So, decision which is taken by the speaker related to disqualification under 10th schedule is subject to judicial review. But in this, right, in this Supreme Court said that such can only be questioned in the court if prima facie these two components are there in the decision of the speaker. If it appears that malified, with bad intention the decision has been taken, or if there is perversity in that decision, then it can be questioned. This was, right, this was the judgment of Honorable Supreme Court of India in the famous, right, case of Kyoto Holohan, right, and this was on this UPSC asked a full-fledged question in the main exam, right, main exam. Now again, since this was a single judge bench, now a division bench of Supreme Court where 3 judges were there, right, when a plea reached, right, when a plea reached to the Supreme Court in which the petitioner was Kisham Meghchandra, and the plea was against the decision of the Speaker of Manipur Legislative Assembly. Now in January 2020, the Supreme Court has come up with a historic judgment, and the Supreme Court, right, the Supreme Court has suggested, right, Supreme Court has suggested that disqualification petitions under 10th schedule, disqualification petitions under 10th schedule should be adjudicated by a mechanism. Now this is by a mechanism outside Parliament and legislative assemblies. So now the Honorable Supreme Court has said that our experience which we have for 35 years related with anti-defection law, right, tells us that let us amend the Constitution of India and we should go for a mechanism where disqualification petitions under 10th schedule are getting adjudicated not by the Speaker and presiding officer of the House, right, but these are getting adjudicated, right, by a mechanism which we can think outside Parliament or outside Legislative Assembly. Okay, this is the conclusion, this is the historic conclusion which has been, right, suggestion which has been given by Honorable Supreme Court of India. And what Supreme Court has even suggested the model of this mechanism, the Supreme Court has suggested that there should be a permanent tribunal, and this permanent tribunal should be headed by a retired Supreme Court judge or Chief Justice of High Court, retired Chief Justice of High Court, right, and this tribunal should entertain petitions which are related with the disqualification under 10th schedule. And what Supreme Court is saying, right, what Supreme Court is saying that this is number one, right, this is number one, but this is only possible if we will go for amendment of constitution, and Supreme Court is giving a logic that this is not going to impact the independent functioning of legislative houses the way it is conceptualized within the Constitution of India, because what Supreme Court is saying, that even judges of Supreme Court and High Court are removed through a mechanism which is outside judiciary. And very correctly the Supreme Court said that if judges are removed, right, through a process where Parliament of India plays a very important role, that is not impacting at all the independence of judiciary or the autonomy of Supreme Court or High Courts, then how come the autonomy of Legislative House will get adversely impacted if there is a mechanism outside Parliament and Legislative Assembly for removal of or disqualification of members under anti-defection law? This is the argument, and very logical, very convincing argument has been put forward by Supreme Court, on the basis of which the Supreme Court has recommended that the time has come when we should create a different mechanism, because existing system is giving birth to acute nature. See what happened presently, the matter is sub judice in the case of Rajasthan, but how come when the House is not in session, some political developments within the political party, and then the Speaker of the House is issuing a notice to some members? The Speaker has a role. When there is some development, when the House is in session and during the proceeding, if something is coming to his notice, right, that, then we can understand, right, then we can understand. But how come immediately the Speaker is issuing? This is something which is, so this is not for the first time which is happening, but on several occasions we have seen such thing. So now have you understood what the Supreme Court has said in this petition which was filed by K. Sham Meghchandra Singh, right, from Manipur? This is number one. And number two, what the Supreme Court has said, right, what the Supreme Court has said, that disqualification, right, disqualification petition under, right, 10th schedule must be, right, must be disposed by the Speaker within reasonable period. So sometime what we are seeing, that the speakers are, right, the speakers are sitting on such petitions, are not taking any decisions, and thereby they are trying to give favor to some political party and political party which they belong, and normally they belong to the political party which is in power. Okay. So now the Supreme Court has said that, okay, if you are not going for amending the Constitution to create a mechanism outside Parliament and Legislative Assembly to decide on matters related with disqualifications of member under 10th schedule, right, then the Speaker should take a decision within a reasonable period. And what has been the reasonable period prescribed? Within 3 months, until and unless exceptional circumstances are there, right? So what Supreme Court has said, until and unless there are exceptional circumstances, the decision should be taken by the Speaker from the date of petition filed before them. Within 3 months they should take the decision. But again, I am also of the view, based on little understanding which I have, that it's high time that we need to take affirmative steps by amending the Constitution to ensure impartial manner in which matters are disposed related to disqualification. Then only we will be able to combat the political evil in India related to, right, related with political defection. And if we want to give 10th schedule of Indian Constitution real teeth, then it will be possible only when we are going by what Supreme Court has said now in January 2020 in this judgment. Okay, in this judgment. So this is right, this is all about disqualification powers of the speaker and what the Honorable Supreme Court of India has, right, what the Honorable Supreme Court of India has said in this regard. So this is a very important topic, and I hope any question on this now you will be able to, right, you will be able to answer. Now the next important topic which I am going to take for discussion, that somehow relates with economics as well, but it is more of, right, it is more of a polity related development. So I am just going to talk about, right, one scheme which has been launched, and the scheme has been launched in the form of a bill which now has been passed by the two houses of parliament, right. So this is very important. This bill got passed, that is direct tax and Vivad se Vishwas, Vivad se Vishwas Bill 2020. Okay. So Vivad se Vishwas scheme is presently under enforcement after, right, this bill was passed by two houses of parliament in March 2020, right. So this Vivad se Vishwas scheme now is under enforcement as bill was passed by the two houses of parliament, and very important, this Vivad se Vishwas, right, scheme is related with direct tax, Now what a wonderful idea, because I hope you all are aware that presently the revenue earning of government has gone down significantly because of economic slowdown and COVID-19 lockdown, and even before lockdown and outbreak of this pandemic, the economy was already in a downward sliding path, and now with lockdown, nosedive, right, is what we can say for the growth rate, and government is struggling with as far as revenue earning is concerned, and that is how a wonderful idea they conceptualized in the form of Vivad se Vishwas, right, bill. So as per this bill, right, basically this bill has, right, created the mechanism, right, actually it has created the mechanism for resolution, of pending tax disputes, and this related with direct tax, right, and primarily income tax and corporate tax, right, related with all direct taxes, but primarily income tax. So we need to resolve, right, the dispute. Now what you should remember, right, under this scheme and as per the provision of this newly enacted law, right, this law allows taxpayers to settle cases, and these are very important from prelims point of view, settle cases, and those cases which are pending, right, before number one, commissioner appeals. So in income tax or corporate tax department, commissioner appeals, right, if any case is pending. Then ITATs, that is income tax appellate tribunals, very famous, right? You must have heard a lot about it, income tax appellate tribunals. So, all cases which are pending before, right, income tax appellate tribunal can be the part of, right, can be the part of this Vivad se Vishwas scheme. Okay, not only that, right, DRTs, again very important, DRTs, that is debt recovery tribunals, right, debt recovery tribunal, any case which is pending before DRT, that can also be settled under this scheme. And not only that, high courts, if the cases have reached to the level of high court, even if the case has reached to the level of Honorable Supreme Court of India, right. So, Vivad se Vishwas scheme, you will find that these cases which are pending before commissioner's appeal or which are pending before income tax appellate tribunals or debt recovery tribunals or high courts or Supreme Court, right, that those can be resolved under this scheme. And you need to understand that why government has gone for that, as per, right, as per an estimate, 4.83 lakh pending cases are there before them, pending cases as on date, right. And if we see, right, if we see, these cases are worth approximately rupees 9 lakh crore. If these cases are resolved, disputed amount is 9 lakh crore, even if 70% if government gets, right, huge money. So, worth these 4.8 lakh pending cases are worth 9 lakh crore of tax revenue which government otherwise could have got. And this is what government wants, very swift and simple way, right, swift and simple way in which government can get significant percent of this money. There is no point that government is also fighting with the concerned party. So, that is why this scheme has been launched. Now, what is the mechanism? What is the mechanism? And again, these dates are very important, right? These dates are very important. What I would like you all to remember, under this taxpayer, because it is Vivad se Vishwas, right? So, under this, the taxpayer, they will be required to pay only amount of disputed tax, right, and there will be complete waiver of interest, penalty and prosecution, right. So, there will be waiver under this, complete waiver of interest, any penalty which has been imposed, right, penalty, and even prosecution notice, prosecution. So, complete only the amount of disputed tax, this is what they have to pay. Now, very interesting, right, since the bill was passed in March, and that was the time when there was a nation, towards the end of the month there was earlier in the bill the provision was that this scheme will this scheme can be availed only if, right, they are going for settlement of the case before 31st, right, of March, but now that got extended to 30th of June. So, what you should remember, this, right, you should remember that this scheme was only if they pay, right, only if they pay the tax amount before 30th June 2020. Okay. So, that is what. Now, this scheme will be available, right, this scheme will be available, scheme available, right, available. This scheme will be, or you can say this scheme very important is the date, right, very important is the date. This scheme can be availed, you can say, availed now till 31st of December 20. The window will remain open till, but those who have settled till 30th of June, they have settled just by paying the disputed tax amount with no interest, penalty and prosecution. But after 30th of June, right, those who will settle, and they can settle up till December 2020, they may be required to pay, right, pay some additional amount. Okay. So this is very important. Vivad se Vishwas, right, scheme. Vivad se Vishwas scheme. Now you know why this scheme was launched and why this bill was passed by Parliament. Because government is having a very good experience of similar scheme which was launched in 2019, and there can be a question even on this. Sabka Vishwas scheme, right, Sabka Vishwas scheme. This was, right, this was launched in the year 2019 and this was related with indirect taxes. And what you would be, right, what you would be happy to learn, right, that this scheme resulted in settling down 1,89,000 cases pending against different tribunals and court related with indirect taxes. So 1,89,000 cases got settled under this Sabka Vishwas scheme which was related with indirect tax, and because of that, during the period of window opening, government was able to raise around 39,500 crore. 39,500 crore, and the application which it entertained, even after the closure of the scheme, the government was able to recover additional 90,000 crore, right. So during the period the window was open, the government was immediately able to, you know, recover 39,500 crore tax revenue, right. And later on the application which it accepted during that window period, which got settled later after the closure of the window, through that government additionally got 90,000 crore. So 1,89,000 cases got resolved under Sabka Vishwas scheme which was launched in 2019 related with indirect tax, and this made government that now if 9 lakh crore worth 4.83 lakh cases, you know, are disputed between taxpayer and the government related with direct taxes, then if we go for some mechanism, then definitely, right, swift and quick way in which government can get some tax, you know, earning. So that is something, right, that is something what you should remember. A very good scheme got launched, and actually when this bill was passed, direct tax Vivad se Vishwas bill 2020 was passed by the two houses of parliament. During that, the provision was that only those disputes which are getting settled before 31st of March 2020, in that the taxpayer can only pay the disputed tax amount, and there will be complete waiver of interest, penalty, and there will be, you know, they will quash the prosecution notice if served to the other party. But because of the lockdown, that what was the window which was supposed to close on 31st of March got extended to 30th of June, and this window will remain open till 31st of December. But anybody who is opting for settlement of dispute through this scheme after 30th of June, in addition to the disputed tax amount, they will have to pay some more amount, because government was incentivizing those who quickly, immediately decided to settle the case with the government, and that is how this scheme was so much in news. So, very, very important. You may say economics, you may say polity, but this topic is important. Direct tax, Vivad se Vishwas scheme 2020. Okay. So, this is about the Vivad se Vishwas scheme. Now, I would just be giving you a brief about one organization which is every day in news, and institution, as an institution you should know that institution, that is ICMR, Indian Council of Medical Research, ICMR. Every day evening in the month of April, we have seen press briefing by ICMR related with, right, related with COVID-19, and even now frequently we are, seeing this organization in news. So, I would just like you all to have awareness, means that what this body is, as it is finding many a times place in the media. So, you should be knowing everything about this. So, I would just like you all to remember that as far as ICMR is concerned, okay, in 1911, it was established in 1911. It was established in 1911, okay, and only after independence in 1949, it was renamed as ICMR. So, it is with the name ICMR since 1949, but establishment was way back during British rule in 1911, and that time it was in the name of IRFA, okay, and later on it was renamed as ICMR. And one thing which I would just like you all to remember, that this ICMR is the apex body in India. It's the apex body in India, and it is for formulation, coordination and promotion of biomedical research. So, formulation, coordination and promotion of biomedical research. So, primarily it is a research organization, biomedical research. Okay. So, primarily it is a research organization, and it holds the distinction of being one of the oldest medical research bodies in the world. Okay. And not only it is a biomedical research organization, it is also addressing, right, it is also addressing the demand of practical solution to health problems in India. Practical solution to health problems in India. So, in addition to promotion of biomedical research, it is also an organization which is, trying to find out that what could be the practical solution to very diverse and complex nature health problems which are there in India, okay, which are there in India. So, what I am just interested, right, what I am just interested in telling you, right, what I am just interested in telling you, that if you see ICMR mandate, right? If you see ICMR mandate, this council research priorities research priorities research priorities coincide research priority coincide with national health priorities. National health priorities. Okay, and management of, and this is where you can expect a question: management of communicable diseases, fertility control, maternal and child health, control of nutritional disorder, developing alternative strategies for healthcare delivery, containment within safety limits of environmental and occupational health problems. Okay, so what I would just like you all to remember, these terms are very, very important, and therefore I am repeating, and you should have full awareness, because there can be a possible question, the area in which this organization is involved. Okay, so it's research priorities, whatever they are researching, that overlaps or coincide with national health priorities, and within national health priorities, right, control and management of communicable diseases is number one, right. Number two is fertility control, so population growth, how to reduce that growth in the population and to keep the fertility rate under control. Then maternal and child health, in addition to communicable diseases, even control of nutritional disorders, very, very important, right. Developing alternative strategies for healthcare delivery and containment within safety limits of environment. But what is, right, what is more important, that not only control and management of communicable diseases, but even, right, even research on major non-communicable disease, right. In addition to whatever we have talked, research on major non-communicable disease, and within that the most important is cancer, blindness, right, cardiovascular diseases, other metabolic disorders, mental health research and drug research. Okay, so I would like you all to remember, because, right, what may be asked, because most of the people now have created a perception about this organization that its main task is research in the field of control and management of communicable diseases. No, even major non-communicable disease like cancer, blindness, mental health, okay, then cardiovascular disease, diabetes, right, lifestyle disease, diabetes, metabolic disorders, all these are the area in which Indian Council of Medical Research, right, Indian Council of Medical Research is working. And I would just like you all to remember that when it was created in 1911 in the name of Indian Research Fund Association, I told you, no, that in 1900, right, in 1911 it was established in the name of IRFA, Indian Research, right, it was established as Indian Research Fund Association, but later on it was renamed as ICMR. So it evolved as a very important body, and today it is one of the premier organization, research organization. No way the status, the reputation of ICMR is less than ISRO or DRDO. The way ISRO is in space research, the way DRDO is in defense research, right? Similar kind of status and reputation, and sometimes I may say that status and reputation even beyond these premier research organization is with ICMR. Okay, So that is something, right? That is something which you should remember. And I would just like you, right? I would just like you to know that if you see ICMR mission, ICMR mission. So ICMR mission can be summed up in few words. First word is generate. The entire mission can be summed up in few words. Generate. So what is that? Generate, manage, disseminate new knowledge. So the first, right, component in the mission is generate, manage, disseminate new knowledge. Then second word is increase, right? Increase focus. So increase focus on research on health problems of vulnerable, right? And particularly those who are going to get affected from disadvantaged and marginalized section of society. So increase focus on research on health problems is the second important statement within the mission of ICMR. The third word can be harness. Okay, harness and encourage the use of modern biology tools, right? So harness, right? Harness and encourage the use of modern biology tools is the third component within the mission. The fourth component is encourage. Encourage. Okay, encourage innovation and translation related to diagnostic treatment methods, vaccine for prevention. This is what presently it is encouraging, that how India can be the leader as far as developing the vaccine for, I hope you all are aware that even under the supervision of ICMR, the vaccine for COVID-19 is in the human trial stage. Okay. So we are also one among few countries in the world which have moved so advanced, right, as far as developing this is concerned, vaccine for this. So encourage innovation, and the fifth word will be inculcate. Inculcate. Okay. So inculcate a culture of research in academia, especially medical colleges. Inculcate, right, the research. So if I have to tell you the mission of ICMR, which is now holding a global recognition, particularly post-COVID, this organization which many people were not knowing, now most of the people have learned. So generate, manage, disseminate new knowledge, encourage focus on research on health problems in the country, harness and encourage the use of modern biology tools, encouraging innovation and inculcating a culture of research in academia, especially medical colleges. This is what is the mission with which ICMR is working, and which all field it's working, I have told you in detail. So that is what, right, that is what you should remember, right, that is what you should remember. Now the next topic which I will take up for discussion again is a very, very important topic about which you all are reading a lot in the newspaper these days, and that topic is New Education Policy 2020. And again, very, very important, we will be talking first about the polity aspect of this new education policy, and then we will see what is there in this policy, right, before we discuss what are some of the concerns, what is the way forward, what can be the possible challenges. So let us talk on national education policy 2020, which is popular in the name of NEP 2020. Okay, but before I say anything about this policy, right, anything about this policy? First thing you should remember, then only you can understand the challenges which is there in the policy. See, through 42nd Constitutional Amendment Act of 1976, education, right? Education as a subject which was earlier in the state list was moved to the concurrent list, right? So, education as a subject moved from a state list to concurrent list. So, before 76, right, it was in the state list, and then, right, after 1976, it was brought in the concurrent list. This is the first thing I would like you all to remember. Second thing I would like you all to remember, that part 4 of Indian Constitution in Article 45, right, Article 45. So, it is directive principles of a state policy. Article 45 and Article 39F. 39F. So, 39F, equitable and accessible education, and Article 45, right, has provisions related with state funded, right, education. So, these two articles relates with, right, these two articles relate with education, one related with state funding and the second related with equitable and accessible education. Okay. The third thing which I would like you all to remember, that 86th Constitutional Amendment Act of 86th Constitutional Amendment Act of 2002, we inserted Article 21A, and right to education was made the fundamental right, but only one uniqueness, that this was the right for those who are in the age of 6 to 14 years, will remain as the fundamental right. And related with this, right, related with this, the country saw RTE, Right to Education Act 2009 enacted, and this provided, primary education to all children in the age bracket of 6 to 14 years, right, and to enforce fundamental right. This act was enacted to enforce this fundamental right, which was inserted under Article 21A way back in 2002, right, way back in 2002. And under this RTE, Right to Education Act, even the private educational institution were, made, it was obligatory for them to reserve 25% of the seats for disadvantaged section of society. So, those who are from disadvantaged section of society, even the best of the private schools were asked that they have to reserve 25% of the seats which are there. And then there is no need for me to tell you, right, to promote education, we saw Sarva Shiksha Abhiyan, midday meal scheme, scheme of Navodaya Vidyalaya, scheme for Kendriya Vidyalayas, use of IT education. So, at different point of time, different, right, schemes were launched. These are the things which you should keep in mind before I talk about the National Education Policy 2020. Now, what I would like you all to remember, that this is the third national policy which has been approved by the cabinet in independent India. The two earlier education policies were brought, right, two earlier education policies were brought, one in 1968, second time in 1986, and now after 34 years in 2020. Okay. So this is the third national policy on education, right, in India, which got approved by the cabinet, and this is after 34 years we are finding a national policy. And I would like you all to remember, before I tell you anything about this national policy, I just want that any kind of prelims related question you should be, you should be fully equipped. This current policy, this 2020 national education policy is based on, right, is based on the report which was submitted to the government by a committee which was headed by a eminent space scientist K. Kasturi Rangan. K. Kasturi Rangan. Okay, so K. Kasturi Rangan committee suggested, and accepting most of the suggestion, the government formulated this national education policy, which now has got the approval from the cabinet, right? Now has got approval from the cabinet. Now, two things before I come into the highlights of this policy. What are the highlights of this policy? So, this NEP 2020 is aiming, right, to make India, right, to make India a global knowledge superpower. Global knowledge superpower, and it is meant for, right, it is meant for complete transformation of education system, complete transformation for education system by 2040. So, completely transformed system of education should be there in India by, right, by 2040 is what is this policy meant for, right, policy meant for, so that we can meet the needs of, right, so that we can meet the needs of education in 21st century. That is what. And I would just like you all to remember a few words, that this new education policy aims to facilitate an inclusive, participatory and holistic approach which takes into consideration field experiences, empirical research, stakeholder feedback, as well as lessons learned from the best practices. So, how we are going to transform the whole system of education in India, right? We will create a education system which is inclusive, participatory and holistic in nature, and that will take into consideration field experiences, right? So, what the government is saying, the best form of learning is experiential learning, right? What you experience and learn, right? So, field experiences, empirical research, stakeholder feedback, right, as well as lessons which are learned from best practices. So, this policy is, before I come into, right, before I come into, because a lot of, right, a lot of focus is on cognitive development of child, social and physical awareness of child in initial days of their schooling in this, right, education policy. So, we will talk about that, right, but from the prelims point of view, right, from the prelims point of view, few things which I would just like you all to remember. This education policy is suggesting that this 10+2 system which is there, this should get replaced. This must get replaced with 5 plus 3 plus 3 plus 4 structure, okay, and this 5 should be in the age bracket of 3 to 8, whereas this 3 should be in the age bracket of 8 to 11. This 3 should be for the age bracket of 11 to 14 years, right, 11 to 14 years, and this 4 should be for those who are in 14 to 18 years. Okay. So, 10 plus 2 system should be replaced with 5 plus 3 plus 3 plus 4 system, right, 5 plus 3 plus 3 plus 4 system. Okay. Now, what I am just trying to say, that in the earlier education policy, the uncovered age group was 3 to 6, because it said that only those who have completed 5 years of age, they should get admitted in the first standard. That was what was there in the 1986 education policy, but now it is saying that they can be brought, right, they can be brought into this. So, what is one unique thing, right, what is one unique thing which we are finding, right, which we are finding, that it is, right, it is bringing children from age 3 to 5 within formal education for the first time, right. So, for the first time what we are finding, that even those who are 3 to 5 years, they are getting, right, included, they are getting incorporated within formal structure, right, formal structure, within formal structure. Okay. And right, second important thing is ensuring continuity in the last 4 years, right. So, ensuring continuity in the last 4 years is another important aspect which you will find, right, which you will find. And this 5 plus 3 plus 3, right, 5 plus 3 plus 3, the 5 which is to be divided into two component, right, which is to be divided into two component, is like a foundational stage. Okay, this has been named as, right, this has been named as, first 5 is foundational, the next 3 is preparatory, right, is what is very preparatory. The third stage has been termed as middle, and the fourth stage has been termed as secondary. Okay, fourth stage has been termed as secondary. Okay, and this foundational stage, right, this foundational stage. Okay, so this foundational stage is a multi-level play activity based learning. Okay, so the entire focus in this, right, entire focus in this, is a multi-level play or activity based learning, play or activity based learning. This is what is the should be the focus in the foundational level. Okay. Then as far as preparatory stage is concerned, it talks about again play, discover, right, play, discover, interactive classroom learning, interactive classroom learning, right, preparatory level. When it comes to, right, when it comes to middle level, right, when it comes to middle level, it talks about essential learning, it talks about essential, not essential, experiential learning, sorry, it talks about experiential learning, and experiential learning, right? Experiential learning in science, maths, right? Arts, social science, right? Social science, okay, humanities, etc., right? Humanities. But secondary level is what it is saying, that in secondary level, right, secondary level, that is the last four, it should be focused on multidisciplinary study. See the word learning is getting replaced, multidisciplinary study, okay, and critical thinking, flexibility, a student choice of subjects are some of the key words which finds mention in the second. So what this new education, complete overhauling, right, complete overhauling, and I am very much impressed that different types of learning is what they could map for different stages, and they this policy talks about 10+2 system to be replaced with 5+3+3+4 system, where the first will be the foundational stage, then will be the preparatory stage, then will be the middle stage, and then will be the secondary stage, and at each stage the focus should be completely different, right? Completely different. Not only that, right? Not only that, what has been said, right? What has been said in this national education policy, that 10 and 12th board, and this will be what is giving a lot of happiness to children, that 10th and 12th board examination to be made easier, board exam to be made easier, okay, and this board exam should not test the ability to memorize, but should test the core competency of the students. So I am again impressed with at least the choice of word, those IAS officers who would have participated in penning down the policy document, right, penning down the policy document. Hats off to the choice of their words, okay. So finally they could think of that this 10th and 12th board exam should not be the test of memorizing ability of the student, but it should test the core competency of the student. And right, and what is so new, that a student should be allowed to take the exam twice in the year. Take 10th and 12th exam, then take exam twice. So every 6 months there will be an exam. Whenever you feel that you are prepared, you take exam, and that exam will not test how much information is there with you, but will test your core competency, is what has been suggested in this new education policy. Okay. Not only that, another important thing, and this is what, too much regulation is there when it comes to higher education. So this policy talks about HECI, Higher Education Commission of India. This will be a single, this can be perhaps the biggest reform, I can say, umbrella, right, regulator for higher education in India, right, for higher education in India. And this will regulate the entire higher education only, right, exception will be excluding medical and legal education, okay. So this will be the regulated. So whether it is engineering, whether it is universities, or whether it is education, or whether it is any other vertical, they all will get regulated by one body, and that would be HECI. The only thing which will be kept out of the purview of this would be medical and legal education. Otherwise, right, everything else will fall within this, right, fall within this. And this will have independent vertical there will be one vertical for regulation. The second vertical will be, it will not only be a regulator, but it will be a, it will be a apex body, right? And it will have four verticals. One vertical will be for regulation, right? One vertical will be for regulation. The other vertical will be for a standard, right? For a standard setting. Standard setting. What should be the standard which should be maintained in the institutions, school, colleges and university. The third would be for funding, from where the money will come. And the fourth vertical within it will be separately working for accreditation. Okay. And which has been kept out, right? Which has been kept out of the purview? Medical and, right, legal education. So separately they will be regulated, but otherwise rest everything will fall within this. Okay, fall within this. Now the most important thing what I found in this education policy, that it also aims to increase the public investment in education sector. This is the most heartening figure, 6% of GDP. So this policy is talking about that at earliest. Now there is no time frame, we will talk about the criticism, okay, but this is aiming at increasing the public investment in education to 6% of the GDP. Okay, now this will be a tough task, right? And government will have to make committed effort on ground if we have to achieve this. So very, very important fact which you should remember, that this education policy is talking about this. Not only that, I would also like you all to remember that GER, another figure which you should remember from prelims point of view, gross enrollment ratio in schools, right? In schools by 2030, it is aiming 100%, right? So I'm just, if you have to remember some figure, one figure is public investment in education sector at earliest, right, to 6% of the GDP, gross enrollment ratio in schools by 2030 should be 100%, right, should be 100%, is what finds explicit mention, right, what finds explicit mention within the education, new education policy of India, right, new education policy of India. And right, in addition to this, right, in addition to this, there are many other, right, there are many other things which finds mention, some facts which are there, right, but I don't want to burden you too much with the facts, right, I don't want you to burden with facts, but yes, when it comes to, right, when it comes to this, see, I would just like you all to remember this, that for technology and foreign institute, right, for technology and foreign, technology related and foreign institute, there will be a national assessment center, national assessment center, and that has been named as, codenamed as Parak, right, Parak, and it will assess the student, right, as far as foreign institutes within India is concerned, and all technology institutes, right, all the technology institutes which are there in India. Okay, so that is something, right, that is something what you should remember, right, that is something what you should remember. In addition to this, if you have to remember one figure, right, that is gross enrollment ratio, gross enrollment ratio for higher education, for schools it should be 100% by 2030, but gross enrollment ratio for higher education to be raised by to 50% by 2035, and presently it is 26%, slightly more than 26%, which we have to make to 50% by 2035 is another figure, if you remember, right? That would be good from the prelims point of view. That would be, so gross enrollment ratio in schools, right, by 2030, 100%. Gross enrollment ratio in in this higher education should be 50%, right? Should be 50% by 2035. What finds a mention in this new policy? What finds a mention in this new policy? Now, there can be, right? There can be many other facts and figure, right? That is what all it talks about complete reform in the entire assessment process, and it should be 360-degree holistic progress, right? That is what has been talked. It also talks about institute of eminence along with central universities in India, right? So too many things are there. I don't want to burden, right? I don't want to burden you, but when it comes to degree, again it talk about 4-year degree where there can be exit and there can be entry with credit system. Okay, if you ask me what caught my attention in this education policy, that it is talking about, right? It is talking about a degree in 4 years where 4-year undergraduate degree, right? What they are saying, 4-year. This is again a very uniquely thought, 4-year undergraduate, right, degrees, undergraduate degrees with, right, with multiple entry exit options, entry exit options, right? And this will be first introduced only in 20 institutions of eminence, right, in the academic session 2021 itself, right? And thereafter it will be expanded. Now, what actually they are saying, that after completing this 5+3+3+4, people can go for undergraduate, where they can join the 4-year degree program, and if somebody is making an exit after 1 year, they will only get a certificate. If they are making an exit after 2 years, then they will get a diploma. If they are making an exit after 3 years, then only they can get a degree, and double degree if they make an exit after 4 years, and they can go and can get field experience and can come back, right? All these things are there. I am just when I was listening to the experts, I said that maybe after doing 1 year, people can make an exit and can prepare for some exam, and then again they can get back and can do the remaining years of their undergraduate course again in between, if they want to work, earn something, right, and learn, right, then they can go and work and can again get back and they can complete their degree. So I am very happy with this kind of very differently thought provisions in our education policy. And very rightly said, right, very rightly said that if you ask me, right, if you ask me, then, right, then it will transform the whole system of education in India. Okay, but if you ask me challenges, or if you ask me concerns, or if you ask me, right, where do the difficulty lies, all such question related with where do the difficulties lie. Now, this discussion mainly is important from the main exam point of view, yet, right, from the prelims point of view, I just want you, right, that many of the proposals, right, will require require legal changes. Okay. Many of the proposals which are there in this policy will require legal changes, and those legal changes are to be done both by parliament as well as by state legislature. So, state legislature. So, the implementation of this policy will depend very much on coordination, collaboration and coordination between center and states. And right now, the federal polity of India is passing through a very tough time. Okay. Particularly, right, the states where the party in power is different than the party in power at center. And if the states will not change the law, then most of the proposals or the provisions of this policy may not see the light of the day. So, one challenge is arising from the very fact that effective implementation on ground can only be possible if we are changing the law, and to change the law not only by parliament but by the state legislature, as education is in the concurrent list within the scheme of constitution. Second is, right, second is challenge is related with funding, right, challenge is related with funding. If we have to implement everything, then we are in need of huge funds. But there is no mapping within the policy that from where we will get the fund to enforce and implement this policy on ground. So, again, right, again it is under assumption that different stakeholders will come forward, right, and would and would invest money, right, with which proper implementation of this education policy will be possible. The third challenge which is arising, that many a place this policy is appearing more to be a vision statement than a policy document. Now, we said that at earliest the public expenditure for education in India should be 6% of the GDP, but how we are going to achieve, right, और कहाँ कम करेंगे, डिफेंस एक्सपेंडिचर कम करेंगे, ओके, या एग्रीकल्चर पे जो एक्सपेंडिचर है कम करेंगे, वेलफेयर स्कीम्स पे कम करेंगे, फ्रॉम वेयर, राइट, दिस इज नॉट फाइंडिंग ए मेंशन, एंड दैट इज व्हाट it is appearing more to be a document, you can say. Gross enrollment ratio in schools, right, 100% by 2035, very stiff and good target, impressive target, but how we are going to achieve, what all steps will be taken, that is not finding explicit mention, right, that is something which is there. So, there are some concerns, right, there are some concerns, there are some challenges. We will do the critical, right, discussion on the new education policy from main exam point of view later. Right now, I want you to prepare this topic from the prelims, and whatever we have discussed today, if you have watched and if you have participated in this discussion, any question on national education policy in the prelim exam, you will be able to solve. So, on this note, I will wind up the session, and I would request you all that please, keep yourself fully updated and informed about the current and the contemporary development. Current affairs will play an important role in the overall scheme of success in the prelims exam, and study well, study 10 to 12 hours now till your prelims, and Team ALS is committed more than ever to support you people, right, so that on 4th of October, when you go to prelim exam center, you are able to give the best shot of yours. So, on this note, I will say goodbye to all of you. See you all next Thursday and Friday for continuation of current affairs discussion for prelims 2020. Thank you very much.